Safaricom is not your ordinary telecommunication company. It's a strategic sovereign property whose divestiture cannot be done at the speed that John Badingongo and Dorcas Oduor wants this court to adopt. But not in our part B, we have raised the following questions for determination: whether the government can use Part 3 of the Constitution of Kenya and Section 74 of the Privatization Act to raise revenue as per the objective of sessional paper number 3 of 2025. That is well elaborated, and I don't wish to regurgitate on what has been written. It is well explained from paragraph 31st all the way to paragraph 57, with well cited cases from both the local jurisdiction and international jurisprudence, my lord. I think we have quoted the case of South Africa to support how this government or this particular regime is not allowed to create its own way of raising revenue outside of the Constitution, Part 2, Article 209 of the Constitution of Kenya 2010, which some of the proponent of this particular divestiture opposed vehemently. The Constitution of Kenya 2010. As to whether the proposed sale of government shares in the 6th respondent violates Article 1 because of the sovereignty of the Kenyan people, Article 10, people participation, and in people participation, my lord, paragraph 76 is very clear. And it is even very sad that John Badingongo did not conduct public participation in his Suba county, so in his Migori county where Suba constituency is. He did not. While we could actually forgive him for not conducting it where I come from, in Narok, because it is there, and Lamu. But of course, we know these are traditionally marginalized counties. But John Badingongo did not even conduct people participation in his own county. I don't know where Oduor comes from. Maybe my good Richard Marwa can tell me, but I suspect he did not also conduct. She did not also conduct public participation. My lord, my ladies, we are highlighting 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17 counties. 17 counties, no people participation was conducted there. And there is no village in this country where there is no M-Pesa shop. And we are being told, they are glowingly talking about how effectively we conducted people participation. It's a lie. And it is a lie by John Badingongo to Parliament and to this court.
Yes, continue.
My lord, from paragraph 104 is to whether the impugned transaction complied with the mandatory requirement of the Privatization Act 2003 and Public 2005 to 2025 and the Public Procurement and Asset Disposal Act 2015 and the applicable Capital Markets Authority. We have quoted cases and we have given facts as defined by our petitioner and expert witnesses that this indeed was done wrongly. My lord, we proceed. We have quoted cases, we need not rehearse them, they are in black and white.
Yes, let me continue.
My lord, insofar as the divestiture of 15% of the Safaricom company is concerned, we are saying that the government does not, just as they were advised by the Law Society of Kenya and they ignored that particular advice, that they are not allowed to sell companies that are profitable. The only window that are given to them is for them to sell unserviceable, obsolete, obsolescent, and surplus assets, of which Safaricom PLC is not part of. My Lord, in our paragraph 144, whether the transaction unlawfully undervalued the strategic national asset in valuation of constitutional principle governing prudent public management and protection of public resources. We have exhaustively explained that, and we have exhaustively indeed demonstrated how Article 10, Article 201 have been violated. Lord, I wish, I hope, I wish to refer this court to paragraph 149 on what the expert witness said about undervaluation. In 149, he says, the transaction of Kenya price 34 per share is materially below the fair value of Safaricom PLC as at December 2025. My weighted central fair value estimate at Kenya shillings 57.90 per share, with the range of Kenya shillings 47 to Kenya shillings 77. The discount of Kenya shillings 23 or 43% represent foregone proceeds to the public of Kenya, approximately Kenya shillings 143 billion shillings. That is what the Kenyan people, whose shares are held in trust by the state, is losing. Going to our paragraph 148, whether the intended transfer of effective majority control over the six respondents threatens Kenyan sovereign national security competition framework. My learned colleague, Senior Counsel Kalonzo, has explained that, but if you want to get the finer details, you get it from paragraphs 148 all the way. My Lord, my ladies, you will be persuaded that the shares that we are talking about are floated in the Nairobi Security Exchange, and any one person can buy. My Lord, we continue arguing that a secondary IPO would have sufficed. And our argument to this fact is that a secondary IPO would be even cheaper than the market price. And the Kenyan people, including the generation Zoomers or Gen Zs, who are not mature, by the time Ironko Nyakera, our expert witness, opened Safaricom IPO in 2007, were not mature. It is the desire of the Gen Z to have a bite at the cherry. Hata wao wapate nafasi ya kumiliki kampuni hii ya Kenya ambayo inamesawa mata na serikali ya Rais Ruto. The Lord, disregard any persuasion that these shares, even if they are floated, they will be bought by foreigners. At least they have disclosed that indeed we intend to sell this company to foreigners. And in those few remarks, I invite my good friend and colleague, Mr. Zaku, to summarize.
Yes, my ladies and